I mean, let me give you just a real simple example. I make $500 a week and I normally work 5 days a week. I take off Friday afternoon, you charge me vacation. My paycheck says salary $450, vacation $50, total $500. That's compliance, because all the government cared about was that total $500. Everybody with me on this? Okay, let's talk about some other issues. Jury duty, witness duty, military duty. The full work week rule applies even though the employer has no control over any of those things. But that's how it's done. So if you have an employee who's called for jury duty, an exempt employee who's called for jury duty, then you have to see that that employee draws his or her full paycheck unless they miss an entire week. So if I get called for jury duty Monday morning, and I'm there Monday, Tuesday, Wednesday, Thursday, they release me Friday at noon, I come back to the office, you owe me a full week's pay. And that makes no difference whether the action has anything to do with the employer. Similarly, witness duty. Notice we call it duty, that's the government. So, you are called as a witness in any kind of court case, whether it has to do with the employer or not. It could be a car wreck, it could be a divorce, it could be anything. That is considered an absence caused by the employer, and unless you miss a full work week, and boy, I cannot imagine a witness having to testify for a full week, at least not in a court case, you would have to pay the employee. Military duty. Ever since 9/11, we have had a significant number of people who wind up getting called up on military duty in one form or another, whether they're Ready Reserve or National Guard or whatever it may be. And the rule on that is this. If I'm called up, let's say on a Wednesday, and my work week is Monday through Sunday, and I have to report for duty, then I have to be paid that full week, no question about it. I worked some of the week, Monday, Tuesday, for you, you pay me my full paycheck. But then let's say I'm deployed overseas for a year. Obviously, the rule is, remember general rule number 2, you don't have to pay employees for any work week in which they do no work at all. So for the 52 weeks I'm deployed, then you don't have to pay me. Then, when I am released from duty and I come back, even if I come back in the middle of the work week, you have to pay me that full work week. So you can dock me for military duty only for weeks when I do no work for you at all. Now, the regulations permit, and I'm surprised at this, but the regulations permit you to credit military pay that they might have received against salary. So let's say my salary is $1,000 a week. I work 3 days for you and 2 days in the military, and let's say in the military I got $300 for those 2 weeks. Well, you could pay me only $700 more for that week instead of my full $1,000. And if you do that, shame on you. But that is permissible under the Act. You can also offset any jury fee. You know, the generous $40 a day that the state of Texas pays you for serving on a jury. Your employer can deduct that from your pay. And again, that's pretty chintzy. All right. Here's an interesting one. Deductions from the pay of exempt employees may be made for penalties imposed in good faith for infractions of safety rules of major significance. Now there's a little bit to unpack there. A penalty imposed in good faith is one where you would have imposed it on anybody who did what that person did. It's not that you're like looking to get even with them or to run them off and you pick on a particular person and say, well, I'm going to penalize you for that. And it has to be a safety rule of major significance. You know, if somebody leaves their drawer open a couple of inches, that's probably not going to do it. But if you have an oil refinery and this person goes out in the back and lights up a big old stogie, then you probably can do anything you want to them. Clearly, the government does not want to interfere with employers' ability to enforce safety rules. Now, deductions from the salary of exempt employees may be made for unpaid disciplinary suspensions of 1 or more full days imposed in good faith for infraction of workplace conduct rules pursuant to a written policy applicable to all employees. Well, what are we talking about here? Up until 2004, disciplinary suspensions had to be for a full week to be uncompensated. But they changed it in 2004, so now if you suspend somebody without pay for a full day at a time, pursuant to the rest of this, that's okay. Now, notice the requirement that it be in good faith. Again, it's not you're trying to run somebody off, but this is what you would do to anyone under the circumstances. And it has to be a workplace conduct infraction, but that conduct rule has to be in writing. So what's a classic example of that? Sexual harassment, very good. I'm a subordinate supervisor in your company, and my secretary walks by and I pat her on the rear end as she goes. Well, of course, you might decide to fire me, and you'd be perfectly within your rights to do so. In fact, my last presentation this afternoon is on discrimination and harassment. But let's say I've been around for a long time, I'm a good employee, I've never done anything like this before, and you decide to cut me some slack. And you want to suspend, and we have a written policy that says don't sexually harass people, and it says that you can be subjected to discipline, including suspension, and so you go ahead and suspend me without pay for 2 days, 3 days, 4 days, whatever it may be. That's the kind of thing we're talking about. It's not some ad hoc deal where you just made me mad so I suspended you. It has to be a violation of a written policy applicable to everybody.